Welcome to the University of Michigan Dentistry Podcast Series, promoting oral health care worldwide.
The legal system is a complex maze of laws and procedures which the public often views as maintaining truth and justice. The laws of the land and specific Michigan laws affect the dentist in all phases of practice. Our guest today is Mr. Edward Goldman, staff attorney at the Medical Center of the University of Michigan. Mr. Goldman's responsibilities include counseling and defending healthcare workers, including dentists. Ed, would you describe the legal system as a guardian of justice?
Well, the concept of justice is certainly an important aspect of the system, but you have to remember that it's an adversary system designed to resolve conflicts. The whole idea of the legal system is to provide a forum where two parties who have differences can come and have the differences resolved.
What are some of the characteristics of the system that allows it to resolve these conflicts?
Well, it is set up to yield some predictability, some standards for conduct. To that extent, it is, in some cases, arbitrary, because it's more important to have a predictable system than a system that yields some kind of ultimate justice in every single case. So it's set up with certain rules, either by statute, in other words, laws passed by the legislature, or by court-decided cases, and it works in a retrospective fashion. You get to go into court, to use the court to resolve your conflict, only after a problem has occurred. And then the system reasons backward to determine if the problem could have been avoided. That causes a lot of problems between healthcare professions such as dentistry and the legal profession. Dentists are very used to looking at problems prospectively. The whole training is to examine a person and make some diagnostic impressions.
Mm-hmm. Beforehand.
Right. Lawyers get a case only after an injury has occurred. And lawyers have the luxury of saying what could have been done to avoid that injury. So there is a system that looks retrospectively at what people have done prospectively, and it causes just intense confusion between the two professions.
Before we get into specific Michigan laws, we should perhaps define a few terms. We often hear the words civil and criminal law distinguished. What exactly is the difference between those two?
Well, there's two major differences. The criminal law system is a system that's set up where society feels the actions you have done are so bad that you need to be punished for them. So it's a system where the state can force you to pay a fine or sentence you to jail for your actions. And it's a system that needs a high standard of proof. As an example, you have to be 90% certain or better that someone has committed a crime before they can be found guilty. The civil law standard says there are certain things that people might want to resolve, certain conflicts, and the state does not think that the conflicts are serious enough for the state to step in and treat them as crimes, but they allow a forum for citizens to come in and resolve their conflicts, and the standard of proof there is a much lower one. It's called a preponderance of the evidence. In other words, if you can prove your case by 51% of the evidence, you win, as opposed to the criminal standard of about 90%. There's a third area of law, too, called administrative law, and dentists would get involved in that through their board of licensing. That's where an administrative agency, such as the licensing board, can hold hearings and decide whether or not to give you a license or to continue your license or restrict your license. The standard of proof there is also a 51% standard. The problem of standard of proof is another area that's a conflict between the legal system and the healthcare system. For example, if I say to a dentist, what happened in a particular case, malocclusion of a jaw or something like that, when they talk about what happened, they're talking in the sense of reasonable medical certainty, sort of like the criminal law standard, about 90%. When I say what happened, I'm thinking of the case as a civil case. So I'm talking at about a 51% level. So we're miscommunicating.
Okay, recently I've been reviewing some Michigan laws, and it seems that some of them are designed specifically to protect the patient, whereas others of the laws are designed specifically to protect the dentist. In terms of the patient, it seems, for example, that the Collection Practices Act tends to favor protecting the patient. What exactly does this law do?
There have been several laws in the past couple of years that group around the idea of consumer protection. The idea of those laws is that the consumer of healthcare services has not been treated appropriately, has not been treated as an informed consumer. There's been too much paternalism by the healthcare professionals. So a series of laws were written to redress that. And the Consumer Protection Act, the Collection Protection Act is one of those. It says that you can't make any harassing calls to try to collect a debt. You can't make any calls late at night. You can't dun to collect a debt. You can no longer call the patient's employer to try to collect the debt. And essentially what it says is if you want to collect the debt, you either start a lawsuit against the patient or you observe very rigid rules on how you can go ahead and collect.
Can the dentist employ a collection agency? And if so, would they be responsible for their actions?
Collection agencies now have to be licensed in Michigan, and you can only employ a licensed collection agency who agrees to follow all the terms of the Collection Practices Act. As a result, probably it is more difficult now to collect a debt, and what a lot of dentists and other healthcare professionals are going to is payment at the time the service is rendered to avoid the whole collection process.
If the dentist did use the collection agency, though, and the collection agency violated some law, who would be
then the collection agency would be responsible because they're licensed by the state, and their license could be taken away.
How does Michigan law handle consent for treatment?
The consent for treatment rules come out of the case decisions, so it's not a statute. And the case decisions say that you have to have informed consent before you can treat. Another example of the court's feeling that the consumer of health care has not been treated appropriately. And the courts are now saying you have to treat people responsibly. You have to tell them what the procedure is, what the risks are, what the benefits are, what alternatives exist to the procedure, if any, and make sure they understand. So you have to impart some of your knowledge to the consumer and try to make the consumer informed, try to make the consumer understand what it is you're going to do, and try to tell the consumer what the options are.
Should this be in writing, or this should be just verbal?
Well, informing the consumer really happens orally. Just like you and I sitting here talking, the dentist tells the consumer what the procedures are, what the risks, benefits, and alternatives are. If the dentist wants to commemorate that transaction, can put it in writing. And that's important to show that the consenting process has occurred. All too often people think that the written piece of paper is the consent itself. It isn't. It's just a written memorandum that consent has occurred. And it's helpful 2 years later in a lawsuit where the patient says, dentist never told me any of this stuff, and the dentist can say, well, isn't this your signature on this piece of paper here?
Right.
And doesn't it say all the things that we discussed? But people get into trouble when they mistake the memorandum for the consent, because all too often they say to a patient, well, now we come to the informed consent part, sign here. That's not informed consent.
Right. Who owns a patient's records in Michigan?
Since 1974, when the new Michigan Public Health Code was written, the physical record, the pieces of paper, are owned by the person generating it, the dentist or the physician or what have you, but the information on the pieces of paper is owned by the patient. And the Public Health Code says that people can read their records at reasonable times and places. It used to be that if a healthcare professional said he or she didn't want you reading the records, you had no rights. And since 1974 and after, or 1978, I'm sorry, since 1978 and after, you have the right to read your record and to get copies of it.
Mm-hmm. You can make the copies yourself, or does the dentist have to provide copies? Or
you can make the copies yourself, or if the dentist doesn't want the chart to leave the office, which is a good idea, then the dentist should make copies and can charge you for the cost of the duplication.
Mm-hmm. Does this same principle hold true for x-rays?
Yes, it does. It's the same idea exactly. If the patient requests a copy of x-rays because they're moving out of the state or even transferring to another dentist, the x-ray itself is a property of the dentist, but the information on the x-ray is a property of the patient, so the dentist would have to, at the patient's request, copy the x-ray film and then could charge the patient the reasonable cost of duplication.
Mm-hmm. Is the confidentiality of treatment covered under Michigan law?
Oh, yes. It's covered in detail in the Public Health Code, and it says that all treatment has to be confidential, and the dentist would be liable for a violation of the statute. In fact, the licensing laws say that one reason to take somebody's license away is for revealing confidentiality. That's a good example of how the administrative law system and the civil law system works. If a dentist violates your rights to confidentiality or privacy by discussing your care with a third party, you could sue for violation of confidentiality. That would be a civil lawsuit. Mm-hmm. Or you could report the dentist to the licensing board, and the licensing board could investigate, and if they felt that the offense was very serious, they could restrict the license or take it away for a period of time.
Mm-hmm. Are there exceptions to this confidentiality?
There are several exceptions, and they exist because the state legislature feels that there are certain areas where it's important for a dentist or any other healthcare professional to report information. For example, if somebody has a stab wound or a gun wound and they come to a dentist, the dentist is mandated by law to report that to the police. Contagious or infectious diseases have to be reported to the Department of Public Health. There are several other areas, specific areas like that. Child abuse, for example. If a dentist sees that a child has been battered and it looks like the battering was done by parents or by some third party, not by falling down
right.
steps on an accident, the dentist is obligated by law to report that. So there are certain areas where society feels it's important to get information where confidentiality does not exist.
If the dentist is sued, then he could reveal this information as well?
If a dentist is sued for...
could reveal the records then can become public and
then the records could become public. For example, if somebody sues a dentist for malpractice right. and says, but I'm not going to let you look at my records, right. obviously that's not anything society can tolerate. So once you sue the dentist for malpractice, the dentist has a right to reveal what's in the records.
We'll be back to discuss specific Michigan laws that protect the dentist after this management fact. We're talking with Mr. Edward Goldman about specific Michigan laws that affect the dentist. Ed, it seems not all the Michigan laws are designed to protect just the patient. Some of them, it seems, protect the dentist as well. Could you describe, for example, the contracts to cure law?
Yeah, that's a good example. It's one where the court system and the state legislature both looked at a problem in different ways. Several years ago, a physician talking to a patient told the patient that if the patient would have a certain operation on his stomach, patient would be totally recovered, could eat anything he wanted, drink anything he wanted, go anywhere he wanted. The physician did the operation, did it skillfully, but it didn't have the desired effect. So the patient couldn't sue for malpractice because nothing had been done wrong. The patient instead sued on a contract theory, said, you guaranteed me a cure, and it didn't happen. The court system said, sounds okay to us, and granted a judgment. The state legislature, at the urging of the professions, who said, well, you know, this was sort of our bedside manner, it wasn't really a contract to cure. Mm-hmm. State legislature said, we think that's right, and we don't want to circumscribe healthcare professionals that much. And they passed a law that said contracts to cure, in order to be valid, must be in writing. So now if a dentist says to you, you will be able to eat anything you want after I do this procedure, your response as an informed patient ought to be, could I have that in writing, please, doctor? Absent that, there is no contract to cure.
And you would recommend that the dentist not put it in writing?
I would recommend that, yes.
Okay. The statute of limitations law also protects the dentist. What are the limits in Michigan?
Statute of limitations is a law that talks about the time limit within which you must bring a lawsuit. That's why I said at the very beginning that the system is not a system that deals in ultimate justice. If it were, then any time you were injured, you ought to be able to recover any time in the future. But the law says you have to bring your lawsuit within a specific defined period of time. If you're an adult, you have to bring a suit within 2 years after the end of treatment, or 6 months for an undiscovered problem. Those happen in some surgery cases where you leave part of a drill in the mouth, for example, and it's not discovered until an x-ray is taken 3 years later. Very rare cases.
So it'd be 6 months after that, 3 years later?
6 months after you first discover the problem,
okay.
Yeah. So 3 years later you discover it, and then you've got 6 months within which to bring your lawsuit. Typically 2 years from the end of treatment for an adult. For a child, since children don't have the legal right to sue until they become adults, the statute of limitations in Michigan is that 1 year after you become an adult is when the time limit expires. So if you have done work on a 10-year-old, there's 9 years before the 10-year-old has to bring a lawsuit. Now, the 10-year-old's parents can bring the lawsuit on the 10-year-old's behalf within 2 years from the end of treatment.
Dentists use a variety of products and materials in their practices. What does Michigan law say about the dentist's liability for these things?
Law is that the dentist is responsible for maintenance of the equipment, but is not responsible for the basic construction of the equipment. For example, if a drill breaks because it was manufactured improperly, there's a series of laws called the product liability laws. And those laws say that the manufacturer is responsible, not the dentist. So if a chair is not made properly and it collapses, or if a drill is not forged properly so that it has a fracture, that would be the responsibility of the company making the product and not of the dentist.
And materials that are used, like the gold in making a crown, that would
same
be
principle.
The same
If the gold was done improperly or had some improper alloys in it, that would be the responsibility of the company and not of the dentist.
The standard of care is an interesting law. It provides protection for the dentist as well?
Oh yes, it's an important source of protection, because what it says is you have to be judged by the standards that your profession creates. People aren't allowed to make up their own standards. The profession of dentistry establishes its own standard of care. And the idea is that as long as you practiced as a reasonably prudent dentist, given your level of training and experience, you can't be held liable. So that it's not an absolute liability. And it's interesting, the standard is not that you have to be successful every time, but that you have to operate in a reasonably prudent fashion.
Is this the community's standards, or?
It's a community standard, except for people in subspecialties, and for them, the standard really is a national standard. Oral surgeons, for example, are judged on the same standard, and there shouldn't be any difference between the skill of an oral surgeon in Ann Arbor, Michigan, or in Chicago, Illinois.
Turning to a whole different set of laws, this licensing regulations, 44 pages of rules and regulations. We can't possibly cover it completely here, but could you briefly describe the intent of these regulations?
Sure. That little book is published by the Board of Dentistry. It has had some changes since the time that came out, because the Michigan Public Health Code has made some changes in it, but it's still an accurate document, and it's one that I'd suggest every dentist in training and every dentist in practice read. It contains several different areas. It talks about the requirements for licensing. It talks about the requirements to be a professional in the various areas, oral surgery and the other areas of dentistry. It has some rules about what standard of conduct you have to keep your license. Talks about not limiting your practice to a special branch without special training and experience. Has one area that I think is honored in the breach more than in the observance, and that's a section that says you cannot use the services of a dental lab without a work authorization with a copy going to the patient, so that the patient can, if the patient wishes, use another lab. I know that the forms for the authorization are set up with a carbon copy, but I think it's very rare that a dentist actually says to a patient, now under the law, here is a copy of this work authorization and you are free to take it to the lab of your choice.
How are these things enforced? These are not criminal or civil laws, so does the patient bring a complaint, or?
This is the other area of law we were talking about earlier, administrative law. It's an area where the patient can bring a complaint to the Board of Dentistry, and then the board can investigate. It's very interesting when you look through the laws to see the kind of power that the board has. The board has the power to investigate and actually suspend a license for violation of the rules. And the law talks about several areas where they can suspend a license. It looks at failure to exercise due care, conditions which impair safety of the patient, incompetence, a very broad area that the board can define, can suspend a license for substance abuse, mental or physical inability to practice, conviction of a misdemeanor or a felony, can, if there's been any fraud or deceit in obtaining a license, that's grounds, obviously, for suspending the license. Practicing outside the scope of the license is grounds for terminating a license. Improper use of a controlled substance, obvious grounds for suspension of the license. And then there's an area called unethical business practices. This is a fairly new idea. False advertising, dividing fees for referral of patients, fraud or deceit in obtaining third-party reimbursement are all grounds for suspension of a license.
How is, if the dentist's license is suspended, what recourse does he have? Is this a courtroom proceeding? Can he defend himself? Or?
This is all an administrative proceeding before the Board of Dentistry, but there are substantial rights written in. The board conducts a hearing, and the dentist has the right to be represented at the hearing by legal counsel, specific right in the code, has a right to cross-examine witnesses against the dentist, right to present the case in detail. So it's structured like a criminal trial with all the rights that a defendant has: presumption of innocence, right to counsel, right to confront your accusers. but it's a hearing before a board of people who are also licensed dentists, so they should understand much better than a lay jury what the rules are.
All right. Thank you, Mr. Goldman, for this enlightening discussion on Michigan law and the dentist. Our guest today has been Mr. Edward Goldman, staff attorney at the Medical Center of the University of Michigan. Join us again as we explore other aspects of the efficient management of a modern dental practice on future editions of By Design.
You've been listening to a presentation from the University of Michigan School of Dentistry, which is dedicated to supporting open learning and open educational resources. This recording is licensed under the Creative Commons. It may be reused and redistributed for nonprofit use. Please attribute materials to the University of Michigan School of Dentistry and redistribute under this same license. For more information on how this and other University of Michigan School of Dentistry recordings may be used, visit www.dent.umich.edu/license.